Great, thank you.
Right. All right, everyone. Like I said, so welcome. My name is Layla Elacy, and I serve as the Education Grassroots Community Partnership Manager here at the National Women's Law Center that's located in Washington, D.C. And I'm joined here by my colleague, Elizabeth Tang, who is a senior counsel on our education team as well, who works with student survivors. So today we're going to be talking to you all on the SAFER Act. And SAFER, the acronyms for SAFER stand for Students' Access to Freedom and Educational Rights Act, which is a bill that states can use to protect students from harassment. Next slide, please. All right, so in addition to Haley's community agreements, we just wanted to provide a content warning as well. So the slides that we'll be discussing today will include different forms of harassment based on sex, race, and disability, and will also include sexual assault. So with that being said, that might be something that attendees in this space have experienced. So please, we want to urge you all to take care of yourself. If you need to take a break, if you need to step away, if you need to turn your camera off, please feel free to do so. We want to make sure that this continues to remain a safe space as it has been. So next, I'm going to pass it on over to my colleague to talk a little bit more about SAFER.
Thanks, Layla. So we wanted to start with a background on what has been happening at the federal level to sort of set the context for why state action is the right step. So federal courts have been really failing student survivors. As many of you know, the Supreme Court created some stringent standards for Title IX lawsuits about 25 years ago. Those cases were Davis versus Monroe and Gebser versus Lagos. And so the lower federal courts have taken those cases, run with them, and made things even worse. I'm going to go over a couple different ways that survivors face obstacles when they try to sue their schools under Title IX for failing to help them with sex-based harassment. So first, they have to prove that the harassment that they faced was severe and pervasive. And so unfortunately, this is really hard to meet in courts. Severe meaning that it was very bad, and pervasive meaning it happened more than once. And so many federal courts have held that the following types of conduct are not severe and pervasive. For example, forced kissing and groping, there was a court that said this is not severe because it wasn't a rape. There was another court that said oral rape is not considered severe enough because it wasn't what they consider to be a true rape, although we know that oral rape is also rape. The court didn't consider it to be truly rape because it was not vaginal rape. And then there was even a court that said vaginal rape would not be considered severe and pervasive if it only happened one time, then it wouldn't be pervasive. I want to emphasize it's not that all courts have said all of these things, but these are examples of what different courts have said. And this is, decisions that have been scattered across the country and have really affected many survivors. A second thing that survivors have to prove when they sue their schools is that there was an appropriate official at the school who had actual notice of the harassment. So I'll tackle these things one at a time. One is that appropriate officials, courts have often said need to be sort of high-ranking people. And so there are a number of school employees that, you would very reasonably report to if you experienced harassment, especially as a student, and federal courts have said, no, this doesn't count. So for example, different courts have said, if you told a professor, doesn't count. If you told a teacher, an athletics coach, a guidance counselor, these people are not people who you can turn to, because even if they know that you've been harassed, the school doesn't have any responsibility to do anything. There was even a federal court that said your superintendent doesn't count. So of course that makes no sense. For a lot of people, a lot of young students, they're going to be turning to the lower, more junior ranked employees for help. But even if they had the knowledge and the wherewithal to go approach their superintendent in their central, administrative office, there have been courts that said that person doesn't count. One court even said anybody who is not a school board member doesn't count. So, we're stacked. We're facing a very a difficult standard. The second piece of it is actual notice. Many federal courts have said that a lot of what you and I would consider to be, sufficient notice doesn't count as actual notice. So there was a case where multiple employees saw a teacher massaging a student's shoulders in the hallway in front of other people during passing periods, even one time removing her phone from the back of her jean pocket. So anybody seeing that would be, you would say, this is suspicious. I need to go investigate further. This is not correct. The court said, well, yeah, this is this is not great, but you know what? I don't think that this means that the employees had actual notice that there was possible sexual abuse. So no dice. Another similar case, there were multiple school administrators, assistant principal level officials who had heard what they called rumors that there was a high school teacher dating several different high school students, not one, but multiple high school students. And the court said, yeah, this is also really bad, but you know what? These are just rumors. I don't think this is actual notice. And so the standards that reasonable, ordinary people would use to address sex-based harassment are not being applied in the courts. Four more things. So number 3, at the federal court level, you need to prove that the school had substantial control over both the harasser and the incident of harassment. And a lot of federal courts have said, well, the school doesn't have substantial control over an incident of harassment if it occurs in an off-campus apartment or off-campus party. Again, not all courts are saying this, but many, many are. And the situation actually gets even worse if you have students from different schools. So I'll give you an example. There are a lot of universities that are adjacent to each other. They're neighboring. Maybe students can cross-register at each other's universities. Maybe they frequently socialize together. Their fraternities and sororities, or their different social clubs will socialize either on campus or at nearby bars together. So let's say Alex at American University has been harassed by Blake at Brown University. Under the current standards, Alex cannot sue American University because American University doesn't have substantial control over Blake. Blake doesn't go to American, Blake goes to Brown, right? But Alex also cannot sue Brown because Alex isn't trying to participate in Brown's education programs. Alex is not a student there, and Brown is going to say, well, we don't owe you anything. You don't go here. So this leaves us in a situation where Alex can't require any of these schools to enforce their Title IX rights. So it's just a really bad situation to be in. Number 4, student survivors have to prove that their school acted with deliberate indifference toward their harassment. And so deliberate indifference is a very high standard. It means you have to be clearly unreasonable, not just regularly unreasonable. So a lot of federal courts have said, well, you have given me a set of really terrible facts, and I have to say this is horrible, but it is not deliberately indifferent. So 2 examples here. There was a school that expelled a survivor for consensual sex. They claimed that she had engaged in consensual sex. Of course, that's not what she was saying. She was reporting assault. But because they believed it was consensual, they didn't believe her, they expelled her instead of protecting her. And the federal court in that case said, that's okay, that's not deliberate indifference. Another example, there was a university that was confronted with a reported harasser who was a football player. And the university actually closed its investigation on purpose so that the football player could transfer with a clean record, a clean disciplinary record to another school. And the court actually acknowledged that the school did this deliberately, but also said, you know what, this is not deliberate indifference. Number 5, this is something that affects schools in the 6th Circuit, specifically institutions of higher education. So that's in the states of Ohio, Michigan, Tennessee, and Kentucky. So in these states, a student in higher education, if they report that they've been harassed by a classmate, they actually have to be harassed again after the school has notice of the first incident. Only then is the school liable for not doing anything. So, you might hear this referred to as the further harassment rule, or what many advocates call the one free rape rule. It is the law right now in the 6th Circuit in higher education regarding peer cases, so student on student harassment. And there were actually schools in both Virginia and Ohio that recently asked the Supreme Court to apply this rule to all Title IX cases across the country in K-12 and higher ed. Luckily, the Supreme Court declined to hear the cases, but this is something that will reasonably probably come up again. And finally, the last barrier that's facing survivors in these federal cases is that there was a Supreme Court decision called Cummings that was passed last year. That case involved a disabled plaintiff. The Supreme Court held that the disabled plaintiff could not sue for emotional distress damages under the federal civil rights laws that they claimed were violated, which were Section 504 and the Affordable Care Act, otherwise known as Obamacare. Those are disability claims, and the Supreme Court decision only applied to disabilities. But unfortunately, a lot of lower courts have started applying the same rule to Title IX cases because they see a lot of similarity between Title IX, which involves sex discrimination, and this disability case. Now, the logic there is flawed. I'm not going to get into the details, but many courts are doing it. And it's really particularly harmful for survivors of sex-based harassment because oftentimes the only type of damages they can prove are emotional distress. If you're a young student, you don't have lost wages. You can't say to the court, I couldn't work and therefore I lost income. So if you can't prove that, maybe you can't prove anything at all. If the student wasn't able to seek medical or mental health care, they might not even have anything to ask for reimbursement. And so the only thing they can ask for is emotional distress damages. And if they can't do that, they actually don't have a case at all. So this is, again, a pretty terrible sort of outcome. I'll quickly also explain how these similar standards have been applied for Title VI, which is the federal civil rights law that prohibits discrimination based on race, color, and national origin, as well as Section 504, which pertains to disability. And so these rules, which have flowed from Title IX, have also then harmed Black and Brown students and disabled students. So for example, for the requirement of severe and pervasive, there was a case where there was a Black girl who was being harassed based on her race by her classmates for 18 months, for 1.5 years. They frequently slapped her, they spat on her, they put chewing gum in her books and her locker, they touched her hair without her permission. One of the students told her, if I didn't take a shower, I'd look like you, Black. So really, really horrific. The court looked at all of this information and said, you know what, this is not severe and pervasive. Here's an example from a disability harassment case involving the requirement of an appropriate official. There were multiple teachers at a school district, as well as the bus driver, who knew that this disabled student at the school was being harassed every single day because of her weight, because she had bowed legs, and because of her legs, she walked with a limp. And the bus driver actually saw this happening every day on the school bus when he was driving her to school. And she actually later died by suicide because of the harassment, because it wasn't being addressed, even though all of these people knew about it. But the court said these were not appropriate officials. So even if they knew about it and they saw it happening every day, they had no responsibility to do anything, and the school had no liability for not doing anything. For the deliberate indifference requirement, another example of race harassment. So there were 3 Black girls. I think this is a case in Texas, actually. They were sisters, and they endured more than 10 years of harassment. There were so many, different types of conduct, but I'll just flag like one of the most serious incidents involved their classmates placing a noose next to the eldest sister's car and using the N-word toward them. So in this case, the school actually did take some action. For example, they allowed the oldest sister to park in the teacher's parking lot, but they didn't really do anything. And you know that they didn't really do anything because this harassment happened for more than 10 years to all 3 sisters. And after the first one graduated, the other 2 actually were forced to withdraw and go to another school because of how bad the harassment was. And the court in that case said, this is not deliberate indifference. The school did not act deliberately indifferent. And finally, a last example, the further harassment requirement, the requirement that you have to be harassed again. There was a Black boy in an elementary school who was being called the N-word by his classmate, and his teacher saw it and didn't do anything. But the court said the teacher's inaction did not effectively cause a later incident where the boy was called the N-word again, and he was also physically attacked by 2 of his classmates. So this is, slightly different from the Title IX further harassment requirement, but as you can see, courts are creating a lot of different types of obstacles for students facing really serious, really traumatic harassment and stopping them from being able to pursue justice in the courts. And so the SAFER Act would address all of these issues. As Layla mentioned, this is a federal bill that's been introduced by Senators Bob Casey and Mazie Hirono, as well as Representatives Debbie Dingell, Johanna Hayes, and Deborah Ross. So at the federal level, this would amend Title IX, Title VI, and Section 504. There are more than 90 civil rights organizations that have endorsed it so far. You have the links there to learn more about the federal bill, as well as if you want to endorse the federal bill. But we are bringing this to you because we also think it's important to remember that states can also act. So as you think about how the SAFER Act can amend these federal bills, these federal laws, states can also do the same and introduce the same type of bill to amend Washington state law instead. So I'll just quickly walk through. We talked about on the left-hand side the current standards, and on the right-hand side sort of explains what the new standard would be under the SAFER Act. So as you recall, currently students have to prove that the harassment that they face was severe and pervasive. Under the SAFER Act, students would have to prove that the harassment negatively altered their ability to participate in or receive an educational benefit, aid, benefit, service, or opportunity. So negatively alter is much easier to prove than severe and pervasive. Currently, students have to prove an appropriate person, which is usually a very high-ranking person, had actual notice of the harassment. In contrast, the SAFER Act would require students to prove that either an employee or an agent or any other authorized person at the school, who's been given authority. So for example, this might include like a vendor, an independent contractor, maybe a parent volunteer. That person knew or should have known about the harassment. And so this is, again, a much less burdensome standard and is appropriate for, the real lived experiences of students and how they interact with adults at their school. As long as that person is either authorized to address harassment or is required by the school to report the harassment to the school, or if there's someone whom the victim believes fits one of those categories. So, this makes sense because if you have a 5-year-old, they're not going to know who's authorized to address what and who's required to do what, but they might think that this person they're reporting to can help them. And so that should be enough if they reasonably have that belief. Currently, schools have to have substantial control over both the harasser and the incident, and this often excludes off-campus incidents. Under the SAFER Act, it would not matter where the harassment occurred. Schools would have to address harassment regardless of where it occurs. Under the current standard, the school has to respond with deliberate indifference, which means they responded like pretty horribly. Under the SAFER Act, schools are liable if they don't respond with reasonable care. And the legislation lays out what reasonable care means. It means the school has harassment training, that there's a policy, that the school provides supportive measures to the victim when they report, that if the victim wants an investigation, if they request it, that they get the investigation, and also that the school takes any other necessary actions, which might include other more, school-wide actions, like maybe taking a climate survey of the entire school, or maybe providing school-wide programming on rape culture or other types of harassment. Currently in the Sixth Circuit, the victim has to prove that they were harassed again after the school knew about the first incident of harassment. Under the SAFER Act, it wouldn't matter whether or not the victim was harassed again after the school knew about the first incident. So there's no more one free rape rule. And currently in many courts, victims are being told that they cannot sue for emotional distress. They have to show physical injuries, financial costs, non-emotional harms. Under the SAFER Act, victims would be guaranteed the right to sue for emotional distress. So again, this is a federal bill, but you can also apply these standards at the state level. I'll turn it back over to Layla.
Thank you, Elizabeth. Yeah, so as Elizabeth had mentioned, this is a federal bill, but states don't actually have to wait for Congress to act. So this bill was introduced in October of 2022 and is planning on potentially being reintroduced later on in the year, but states don't have to wait for the Congress to make a decision. So states can pass the SAFER Act to protect students. So this would look like students' ability to sue their schools under their state's civil rights laws instead of having to meet the stringent federal standards of Title IX, Title VI, and Section 504. And so if you are interested in adopting this bill within your state, within the state of Washington, and would like to learn more about the bill and to see a model state bill, you can email Elizabeth. Her email is here, and we'll also make sure to put it in the chat as well. And then lastly, I want to just speak to a few more provisions that the SAFER Act entails. So there's supportive measures. So supportive measures require schools to notify students who report harassment about supportive measures. So this could include class or bus or lunch or club schedule changes, homework or exam adjustments, and or counseling. There's also anti-retaliation. So this prohibits schools from punishing complainants for drug or alcohol use, self-defense, avoiding contact with the harasser, i.e. the student has been absent for a longer period of time from school, consensual sexual activity, and false reports of harassment without actual evidence. And then this prohibits conversion therapy against LGBTQI plus complainants. Also trainings. So trainings will be required for schools to conduct annual training on harassment for all staff and require State's Department of Education to provide grants to schools for such training. Enforcement allows the State's Department of Education to levy fines against schools and violate a state's civil rights law. Transparency requires the State's Department of Education or Attorney General to publish first a list of schools that are being or have been investigated, sanctioned, or subject to resolution agreement for violating a state's civil rights law, and two, any related findings or resolution agreements. And then lastly, data collection, which requires the State's Department of Education to conduct an anonymous climate survey in K-12 schools about K-12 students' experience with and attitudes towards harassment, and to publish the results online. So that is the end of our presentation, and we're going to pass it on over to Tristan for any questions.
Thank you all so much. That was really challenging to hear and really frustrating, to say the least, but we appreciate all of the work that you all are doing to bring this to the state level, because as we know, it can take a really, really long time to pass legislation at the federal level, and states have the ability to pass legislation quicker. And so I appreciate what you all are doing to address the holes in these protections. Does anybody have any questions for our presenters? I have a couple. I'm wondering if you all sent over the draft of the state bill. I'm wondering if you have an updated one, or if I can share the draft that you have with our advocates.
Yeah, that's a great question. I know we had been emailing about that a couple of, maybe, I don't even know at this point, maybe a couple of weeks ago. And I think I told you we were still ironing out a couple of language changes. I'm gonna share my screen. Let me check to see if there is an updated one. I know we're still ironing out a couple things, as Layla mentioned. We are planning to reintroduce this bill at the federal level. And so there have been some changes made in the federal bill, and a lot of those would also make sense in the state version to improve it, to strengthen it. And so that's what I'm holding off on. But I'm happy also to just sort of preview the model state bill on this call with folks if you're interested in just seeing what's in it. So I'll just, I can just share my screen really quickly.
Yeah, let's take a look at it. I also noticed that there is no fiscal note. Do you happen to have an idea of how much this would cost, or does it really depend on the state?
That is a great question. I think it really depends on the state, and the model bill sort of, you'll see it sort of creates placeholders, and that's a really great reminder. I should have had a placeholder. I mean, the fiscal note is typically separate, I think, from the bill document itself, but that's a really great reminder that that's going to be a question that many states will have. So this is the model bill. As you can see, there's like a findings section at the top, which just sort of creates a placeholder for you all as the experts on this issue in Washington to add the statistics and any other data or fact patterns or things that you've seen in your state. The definition section starts with defining harassment. And as I mentioned earlier, it would change the standard to negatively alters instead of the current severe and pervasive standard. As you can see, there are a lot of highlighted placeholders for where, Washington code might be the right thing to cite. So that's what that is. And then there's actually a comment section to explain the text up here. So the idea was that we wanted to create a document that could be easily accessible to students and survivors who are not lawyers or professional advocates. And so we have boxes that, in each section explain. And the explanation will be old to you because we sort of presented it just now in the slides. But you can feel free to pass both this document when it's finalized, we get it to you, and the slides to, students and other survivors who are interested in, learning more about this bill. In section 2, it talks about the liability for harassment. So when a school will be liable, and there's different sections on when the harassment is done by an agent or employee or an authorized person of the school, as well as when it's done by others. And the non-agents, non-employees, and non-authorized persons would include, for example, student harassers, as well as guests, third parties, right? So there's just all these different types of people who could be a harasser, and the bill wants to account for all of that. And then, of course, there's another box down here that explains all of this, because many students will look at this and say, well, where does the bill talk about student-on-student harassment? So we want to make sure that this legalese is explained in a way that makes it easy for students to understand, including students in high school. And then, as you can see here, there's a box, we explain who's protected, off-campus harassment, how that is addressed, harassers with school authority, harassers without school authority. Down here, you have a section about notice. When is a school considered to have notice of harassment? As you recall, the current standard is actual notice. We want to change that to knew or should have known. So that's what that is here. And then we have sort of a carve out here for confidential employees, because we know that reporting is hard and many people don't want to report to someone if it escalates the situation out of their control, right? When assault has happened and the victim's autonomy has been taken away from them, we want to make sure that anything that they do to seek help doesn't further erode their autonomy. So by carving out confidential employees from this notice provision, we want to make sure that students have a mechanism for reporting to someone who is not going to tell anybody else about it. And that can be under, if Washington State has a law about confidential employees, you can insert that. But also we know the Biden's upcoming Title IX regulations also will talk about confidential employees. So, that's what these placeholders are there. And again, we have these, boxes that explain who's required to help, what counts as notice, exception for confidential employees. And then we have some optional sections. We know different states have different requirements for confidential employees. Some may not at all. And so depending on what is in a current state's, state code, they could add more provisions around confidential employees, including, language that, for example, here for disclosures of harassment in K-12 schools that do not rise to the level of possible child abuse and therefore trigger mandatory reporting laws, the state can say that confidential employees are allowed to not report the harassment to the school or to law enforcement, etc. Here we have the affirmative defense, and this is what I was saying earlier. A school has to respond with reasonableness, with reasonable care. And so that has 4 sections. 1 is that they have policy and training and a complaint procedure. 2 is that they have provided, 2 is that if requested by the victim, then the school has conducted an investigation. Number 3 is that the school has provided supportive measures to the victim. Like Layla said earlier, changes to the class schedule, a safety plan, counseling, homework adjustments. And then number 4 is a catch-all sort of thing, any other necessary and appropriate corrective action. So here again is the explainer for all of this. And then this is the text that would get rid of the one free rape rule, the further harassment requirement. So a showing that the harassment did not recur after the school received notice does not establish reasonable care unless you've done those 4 things that we said above. So
would that clause need to make it in there for states not in the 6th Circuit?
Sorry, can you say that one more time?
Because that only applies to the 6th Circuit states, correct?
Yeah, currently in case law, which, in decisions that have been passed by the courts, that only applies to institutions of higher education in the Sixth Circuit. But, different courts often borrow from each other. So if you want to forestall that from happening, it's good to just explicitly codify that in the state law. And of course, again, this language is kind of hard to understand if you don't have the ins and outs of it. So many students will say, well, where's the section about the one free rape rule? And so of course we want to say in the box, this explains what that is. So that's what these boxes do. We talked about emotional distress damages earlier. And so this private right of action paragraph talks about how you can sue for emotional distress. And then we have a comment on it. We also have a section that excludes any money that you get from these cases from taxable income. That's very important because if you want to get a certain amount of money back and then you have to be taxed at whatever percentage for it, you're actually still not made whole at the end of the day. And that's really unfair to survivors of any type of harassment. So that's what this is. I know I went over it really quickly and I scrolled really quickly, but hopefully this sort of gives you a sense of like what's in the model bill. It sort of echoes what you saw in the slides. And also we have additional optional sections here for defining sex to make sure that it includes, not only harassment, but also pregnancy, sexual orientation, gender identity, parental status, caregiver status, actual and perceived characteristics, as well as associational discrimination, when you're harassed because, let's say, a student is harassed not because they're gay, but because their parents are gay. So really just having the bill as comprehensive and protective as possible. And then Layla had mentioned on the final slide that you saw other pieces of the bill like supportive measures, anti-retaliation, training, enforcement, transparency, and data collection. So these are also additional pieces that you could add into a state safer bill. We didn't want to make the model bill extremely long because then it just becomes so unwieldy to like look at. But if, and a lot of times many states already have law codifying many of these provisions, but, to the extent that you don't, we would be, very happy to work with you and provide sample language that you could insert. And again, make it as appropriate for what you all know fits best for Washington State.
That was sort of my next question is, do you know if any states have adopted this particular model bill?
So this is very new. The federal bill was only introduced in December of last year. And so December, of course, was right before the state legislative session started in January of this year. So we have been moving slowly and intentionally and doing outreach to state advocates. We want to make sure that we're working with, the state policy experts, with students and other survivors to see that, the bills that you all want to introduce with the language that you all want is included. We're not trying to move quickly. And so this hasn't happened yet, but, our outreach includes doing presentations like these, doing the presentation that we did with Girls at the Margin. That is how we got connected to you, Tristan, and so forth.
Yeah, that's great. Awesome. Are there any final questions for our presenters before we move on? All right, well, thank you so much, Layla and Elizabeth. We really appreciate your time and your energy and all the work you're doing on this to protect young people all over the United States. But we will definitely keep in touch and, potentially talk about in this group if this is something that we're interested in, pursuing in our state. So thank you again very much for your time.
Thank you so much for having us.
Great. All right, I'm gonna stop.